I'm here with former DUI enforcement officer Michael Scafidi, who's now one of the top DUI defense lawyers here in Murrieta. And Mike, I know that you've had a lot of success defending clients with DUIs in Murrieta, Temecula, here in this sort of southwest region of Riverside County. Let me ask you, first of all, if somebody does get a DUI conviction here at the Southwest Justice Center, what are they looking at in terms of penalties?
Typically, if someone suffers a DUI conviction at the Southwest Justice Center, they're looking at 4 specific consequences. The first one is they're going to be on summary probation for 3 years. The second is they're going to pay fines and assessments of about $2,500. The third is they're looking at between 6 days and up to 30 days in county jail. And the final and fourth consequence is going to be they're going to have to attend and enroll in a first-time offender drinking driving program. It's known as the AB 541 class.
DUI school.
DUI school.
So a big distinction here in Riverside County is that there's jail time that's imposed even on a first offense.
That's correct. Typically, you're looking as low as 6 days, and on many occasions, up to 30 days.
And the difference would just be if it was a high BAC, if there was an accident, aggravating factors like that.
That's correct. Typically, on a higher BAC, it's going to add some jail time. Traffic collision, minor damage, some additional jail time. Moderate damage, some even more additional jail time.
Now, what about a second offense DUI here in Riverside County? How does that differ?
You're going to have the same consequences as the 4 we just described, but there's going to be additional penalties. For example, jail time can range from 30 up to 90 days, typically. And it can be more depending on aggravating factors. And you're going to have to enroll and attend in the second-time offender drunk driving program, known as the SB 38 class, and that lasts 18 months.
So instead of a 3-month DUI score, you're looking at 18 months.
Correct. And the final thing that Riverside County adds on a second offense that neighboring San Maria County does not, the summary probation period, instead of 3 years, it's 4 years.
Now, what about third time? Third time DUI, Riverside County, what's someone looking at there?
You're typically going to see on a third-time DUI in Riverside County is between 120 days in county jail up to 365 days in county jail, as well as the fines of up to $2,500. And when you do get your license back during the 4 or 5 year probationary period, they're going to have you put an interlock device on your vehicle.
So in terms of jail time, you're looking at on a third time, minimum of 4 months, but up to a year.
That's correct.
So let me ask you this, Mike. You've had a lot of success defending clients who are charged with DUI.
We've had great success.
And what are some of the things that you do to help clients win cases?
We subpoena the officers to the DMV hearing. We cross-examine them. We subpoena the videos that are in the most police units now.
The videos that sort of depict the roadside DUI investigation.
From the observations a minute prior to the stop being made, to the roadside contact, to sometimes the field sobriety test. We also subpoena any calibration and maintenance records for breath machines, evidentiary breath test machines, and blood documents, blood run sheets if there's a blood test.
And a lot of times the breath test and the blood analysis, there's mistakes that are made that can really undermine the prosecution's case.
Absolutely. The collection of that evidence and the testing of that evidence is controlled by California Code of Regulations Title 17. And many times, in many cases that we defend, we see that the labs have made mistakes or the actual initial collection by the officers have been done in error.
So as horrible as these penalties are that you described, if you have a good DUI defense lawyer, it may well be possible to get the charges reduced or dismissed and save your driver's license.
I would agree with that 100%. No case that the DA has and brings forth is completely 100% foolproof for them. There's always things that come up to defend the case, to mitigate a case. And in a lot of cases, they get cases dismissed.
Even if you blow well above the .08, the situation is rarely hopeless.
Rarely. In fact, I think some of our greatest successes don't lie with the great results we get on the low blood alcohols, the 08s, the 10s, the .12s. I think some of our greatest results have really occurred with elevated blood alcohol levels 2 times the legal limit, 3 times the legal limit, because then we have all these tools, resources about the technical issues, and we get the cops at DMV. There's no DA there to protect them. We basically have them under oath for hours at a time to break down their testimony.
And finally, Mike, I want to ask you about if a client does have a DUI case, about contacting you, because they may be unsure whether they want to get a lawyer, use a public defender, just plead guilty. If they want to come sit down with you, have you go over their case, give an assessment of what can be done. Do you do that for free? Is that a service that you offer?
We do. We do free consultations for people. And you know what, Neil? I made a pledge that I have kept since the day I became a lawyer 15 years ago. And that pledge was that I will give a free hour of my time to anybody who's facing prosecution in our criminal justice system. It's something that I decided to do as a lawyer and as a human being, because I have seen too many times in my lifetime, in the 32 years I've been in the justice system, people pleading guilty to charges that they're not guilty of.
So it would behoove someone, before they go in and plead guilty and get this on the record and suffer all those consequences, at a minimum to come sit down with you for an hour, go over their case, and talk about what you can do for them.
Absolutely. There's not a lot of things in life I guarantee, but I guarantee when they leave that meeting, they'll know more about their case and more about their rights than they did when they walked into that meeting.
And of course, people are struggling. A lot of people are struggling here financially. A lot of people are out of work. And some people are sort of intimidated, think they cannot afford a lawyer. Do you have like payment plans and special arrangements that you make to fit people's budgets?
We do. How we set our scale of charging people for DUI cases is I look at what's fair to the client and what's fair to us. I have a really good idea when I do an initial intake how much work is going to go into a case. I know exactly from talking to the client what is going to be involved, what subpoenas are going to be done, what testimony is going to be drawn out. So I have a really good idea. So I understand what's a fair price for the lawyering, and I look for a fair price for the client. And what we do is we do allow them to make payments.
So even if they think, gosh, I can't afford, $3,000, $4,000, $5,000 for a lawyer right now, they should still come talk to you because you'll work with them.
Well, not only work with them, plus they're going to get that free hour consultation, and they're going to leave that meeting with so much more information than if they hadn't taken that meeting.